Hello students and welcome to the lecture. So students, as we know that we are covering the general awareness and basically civics part of it, all right? And this is the topic we are covering, civics, okay? And basically we are discussing the organs of the central government, okay? Which are as executive organ, okay? Thereafter we have the legislature organ and then we have the judiciary organs, okay? These are the organs which we are discussing. How many of them we have finished so far? We have finished the executive part. We had finished the legislative part. We are now discussing over this one, judiciary part. We had started the judiciary part in the previous lecture. So I hope that before coming to this lecture, you have watched that lecture carefully so that you could have an idea about it. All right. And executive and legislature parts we had finished to the previous of the previous lectures. All right. So it's my humble request to you, kindly go through these lectures thoroughly so that you will be able to do this thing. All right. So this is what we are discussing so far. All right. Executive part, we know that they are required to implement the policies which are made by the legislature, and judiciary is required to follow up these provisions. All right. And to ensure that the rights of nobody in this country should be waived off. All right. So in the previous lecture, we had completed the Supreme Court. We had completed the Supreme Court in the previous lecture. In this lecture, yet to be discussed, we are required to go further with these two courts. Okay. I hope that you have revised the Supreme Court thoroughly before you have come for this lecture. Okay. So let's start. So basically, we are going to cover the High Court first as an overview, because as we go to the back lecture and we discuss the hierarchy which I had told you in that lecture, hierarchy, then what was it? Third, 2, 1. Supreme Court, okay. High Court, okay. Subordinate court, that's it. Okay, that was the hierarchy. Got it? So Supreme Court we have covered, High Court we have to cover now, and subordinate court we will cover after the High Court. Okay. So remember this hierarchy first. Now let's have a look on the High Court overview. High courts in India are the principal civil courts of original jurisdiction in each state and the union territory. All right. High Court exercises its original civil and criminal jurisdiction only if the subordinate courts are not competent to try such matters for lack of pecuniary or territorial jurisdiction. High courts are also the courts of appeal in their respective states and union territories. Here are the key articles in the Indian Constitution pertaining to the high courts, which we are going to cover. All right. So remember, here are some points which we require to be identified. The first is original civil and criminal jurisdiction. Only if the subordinate courts not competent to try such matters for lack of pecuniary or territorial jurisdiction. Okay, suppose I have told you High Court is responsible for the entire region of that state or the UT, whereas the Supreme Court is covering entire territory of India. All right. So here we have a state. We have a 2 districts here, A, B, C, D, E, and F. 6 districts basically we have here. Okay, now condition appears that the district A having some issue. District A having some issue. All right, but the issue comprising district B also. All right, so now subordinate court, because they are the district courts basically. So the district court of B only having the jurisdiction in the B. District court of A only having the jurisdiction in A. It means that none of these district court could exercise the entire jurisdictions because they having the limited area and the areas lies outside their jurisdiction. In such a case, this matter could be referred to the High Court, because in now the subordinate court, due to the jurisdiction territory, is not able to handle this matter. Okay, and if the matter comprising of the constitutional matter or something else in which the High Court gets satisfied that the subordinate court is not able and competent to handle such kind of matters, then the matter should be transferred to the High Court. Got it? This is the criteria. All right. Courts are also the courts of appeal in the respective states and the union territories. All right. But not on the national level, because on the national level, Supreme Court having the authority. Thereafter, we have the Article 214 in the High Court Judiciary. High Courts for states. This article states that each state shall have a High Court. However, the common High Court may be established for 2 or more states or for 2 or more states and the union territory. Okay, remember this is a condition. Basically, under Article 214, what we have aspired that every state must have their own High Court. Okay, it does not mean if the 28 states in the country, it means that there must be 28 High Courts. Okay, it is not necessary condition, because some states having the common High Court. All right, for example, suppose state B and state A, they having the common High Court. Okay, and C and D, they having the separate High Court. If the condition is like that. All right, so here we have 4 states, but we have only 3 High Courts, because 2 of the states having the common High Court. So remember this thing. If the question asks you that India having the equal number of High Courts as the states having, no. States number and the High Court numbers may be differed because some of the states having the common High Court. All right. Thereafter, we have the article number 215. High Courts to be courts of record. Like the Supreme Court, High Court also having the court of records. Declares every High Court to be the court of record and vests it with all the powers of such a court, including the power to punish for contempt of itself. All right, which means, like as I have told you, in the case of the Supreme Court, whatsoever proceeding has been done, whatsoever orders has been passed, this all kind of things is maintained properly. Okay, and in between of the proceedings, some order has been released to the respective person or the authorities to be followed, and the person or the authority is not ready or not able to follow this. Okay, in such a case, the court could use this record as the evidence against that person or the authority, or will punish that person or authority in the name of contempt of court. Okay, it means the court has asked you to do something which is the legal binding thing, but you denied to do it. Okay, the same power vests with the High Courts. All right, so High Courts also having the powers of court of records. It means that they could record their proceedings and orders if they've been passed to the individual authority, and if the individual or authority is not obeying the orders, then the High Court could use these orders as an evidence and could punish them for the contempt of court. All right. Now let's move forward. We have the 216 article number, Constitution of High Courts. Okay. Specify that every high court shall consist of a chief justice and such other judges as the president may from time to time deem necessary to be appointed. Okay. Here is one thing which is required to be remembered. What is that? Basically, High Court also having the Chief Justice, but the Chief Justice is only known as the Chief Justice of High Court. Whereas the Chief Justice of the Supreme Court is known as the Chief Justice of India. Because the Supreme Court having the power of a nationalized level, whereas High Court only having the power to the respective state or two or more states. Alright. And the Chief Justice and the other judges are appointed by the President of India. Alright. Thereafter, we have the article number 217, Appointment and Conditions of the Office of a Judge of a High Court. Details the procedure for the appointment of High Court judges by the President of India and what are the qualifications and what are the conditions to be appointed as a judge of a High Court. First, must be an Indian citizen. Okay. Second, must hold legal office for at least 10 years. Okay. And by the latest notification, must be legally practicing for 7 years. Okay. So this is the eligibility criteria, and utmost eligibility is that distinguished jurist in eyes of President. Okay. So these are the conditions. Must be an Indian citizen, must hold legal office for at least 10 years, must be legally practicing for 7 years as an advocate or whatsoever, and must be a distinguished jurist in the eyes of the President. If the person fulfills these conditions, he or she could be appointed as a High Court judge. Then we have 218, Article 218, Application of certain provisions relating to Supreme Court to the High Court. The provisions of the constitutions that apply to Supreme Court judges also apply with necessary modifications to the judges of High Court. Why? Because when the Supreme Court having the jurisdiction on the entire territory of India, the High Court having the jurisdiction within the respective area of the state or the respective areas of the states in case of more than one states. All right. Then we have Article 219, Oath or affirmation by judges of High Courts. Okay. Specify the oath or affirmation to be taken by High Court judges before they undertake the duties of their office. And this oath and affirmation has been taken before Chief Justice of High Court of that particular High Court. All right. Thereafter, what we have the Article 220, restriction on practice after being a permanent judge. Okay. After having held office as a permanent judge of a High Court, a person shall not practice in any court or before any authority in India except the Supreme Court and other High Courts. Okay. It means that if the person has been appointed only as an ad hoc judge, acting judge, whatsoever, okay, in such a case, the person is allowed to do the private practice of himself. Okay, but once the person has been appointed by the President of India as the permanent judge, then the person is not allowed to do the personal practice in any court or before any authority. Only two exceptions: Supreme Court, when the Chief Justice of India appointed that person as an ad hoc judge and acting judge. Second, in the other high courts, if there is a lack of decorum. In these two conditions only, the person could be transferred from here to here. All right. So remember this thing. Then we have Article 221, salaries etc. of judges. Pertains to the salaries and allowances of High Court judges, which shall not be varied to their disadvantages after their appointment, except during a financial emergency. Okay, here remember one thing. Consolidated Fund of India basically provides salaries to whom? Judges of Supreme Court. Okay. Second is Consolidated Fund of State provided salaries to the judges of High Court. Remember these two things. Okay. And one thing also, once they has been entered in their office, once they have been elected as a judges, so whatsoever salary and allowances has been promised to them could not be decreased, okay, or could not be altered, amended or changed until or unless there is a case of national financial emergency in case of Supreme Court or state financial emergency in case of the high courts. All right. Remember this thing. Thereafter, we have the Article 222, transfer of judge from one high court to another. The President may, after consultation with the Chief Justice of India, transfer a judge from one high court to any other high court. Okay, suppose we having the High Court of State A, here is the High Court of State B. Okay, we having 31 judges here. We having only 27 judges here. In such a case, if you look at them, you will find out judges number here is quite fine in comparison with this one. Okay. In such a case, if the state B High Court requires additional judges, such a condition, President will consult the Chief Justice of India. The Chief Justice of India will consult with the Chief Justice of High Court A, and then on the consultation of the Chief Justice of India and him to the President can transfer some judges, one judge from A to the B. All right. This is under the Article 222. Okay. Or you can say 222. Thereafter, we have Article 223, appointment of acting Chief Justice. In the event of the occurrence of any vacancy in the office of Chief Justice of High Court, the President may appoint the senior most judge of that court as the acting Chief Justice. Similar case with the Supreme Court, similar case with the High Court. Thereafter, what we have the Article 224, appointment of additional and acting judges. This article empowers the President to appoint additional judges for a temporary period not exceeding 2 years in case of temporary increase in the business of the High Court or for errors of the work. Okay, it means the President is empowered to appoint the additional judges for a temporary period but must not exceeding 2 years in case of a temporary increase in the business of High Court or for errors of the work. Okay, if suppose the High Court is only having the strength to look after the following cases, and suddenly there are so many cases increased or filed with that High Court. In such a conditions, the High Court will not be able to handle all these kind of things. So the President of India may be appointed the additional judges, but only for a temporary period, which should not cross the tenure of 2 years. Okay. So this is provided under the Article 2 to 4. Now let's move forward. Thereafter, what we have the Article 2 to 4A, appointment of retired judges at sittings of high courts. Okay. With the consent of the President, a Chief Justice of High Court may request a retired High Court judge to sit and act as a judge of the High Court for a temporary period if there is a shortage of the judges. Similar, like the Supreme Court, where the Chief Justice of India, with the prior consent of the President, could appoint any retired Supreme Court judge or High Court judge to act as a sitting judge. Similar case with the High Court. The Chief Justice of High Court, with request to the President, could appoint any retired High Court judge to sit and act as a judge of the High Court for a temporary period. Alright. Moving forward. Article 2 to 5. Jurisdiction of existing High Courts. It states that jurisdiction of existing High Courts and the power and authority of their judges shall remain the same as immediately before the commencement of the Constitution. It means their powers could not be curved, their judges' strength could not be curved, but only could be increased. Okay. Then what we have? Article 2 to 6. Power of High Courts to issue certain writs. Okay. Grants High Courts the power to issue certain writs, including habeas corpus, mandamus, provision, quo warranto, certiorari, or any of them, for the enforcement of the fundamental rights and for any other purposes. Okay. Remember, these writs could also be issued by the Supreme Court under Article 32 and by the High Court under Article 2 to 6. Okay. But remember, here is one condition. Supreme Court generally may issue the writs only on fundamental rights, but the High Court is able to issue the writs against the fundamental rights as well as other required matters. Alright. So remember this thing. Supreme Court, fundamental rights. High Court, 2 to 6 for this one's. Supreme Court for this one. Okay. High Court 2 to 7. Power of superintendence over all courts by the High Court. High Courts have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. It means if we having the state A, doesn't matter however how many district courts and the tribunals presented in this state, all of them comes under the High Court. Okay, by the virtue of 2 to 7. Alright. Thereafter, what we have the Article 2 to 8, transfer of certain cases to High Court. If the High Court is satisfied that a case pending before a subordinate court to it involves a substantial question of law as to the interpretation of the Constitution, it can withdraw the case and may either dispose of the cases itself or determine the question of law and return the case to the lower court. Okay. So remember this thing. If the High Court is get satisfied that the case pending before the subordinate court includes the interpretation of the Supreme Court, interpretation of the Constitution, such a cases it can withdraw the case and may either dispose the case by itself, determine the question of law, and return the case back to the court from which it had been taken up. Okay, by the virtue of 2 to 8. Thereafter, what we have the 2 to 8A. Alright. Special provisions as to disposal of questions relating to constitutional validity of laws. Okay. This article, which was repealed by the 43rd Amendment Act of 1977, dealt with special provisions for the disposal of questions relating to the constitutional validity of laws. All right. So students, here we have finished the High Court. All right. In the next lecture, we will try to finish the subordinate code. Till then, just revise the facts and figures we have discussed in this lecture and be ready for the another lecture.